suppressors are in fact protected arms under the Second Amendment.
It's not a final decision on the merits of this case. And today the Supreme Court has answered that question,
which challenges the constitutionality of the NFA as it applies to suppressors.
Everybody has a right if they're a responsible adult.
The federal government just admitted something extraordinary. Suppressors are protected arms under the Second Amendment. They actually said it, and yet somehow they're still trying to keep them regulated under a law from 1934. That contradiction is now sitting on the desk of every Supreme Court justice in the country, and what happens next could reshape firearms law in ways we haven't seen in over a decade. This isn't hypothetical anymore. This isn't speculation. A formal petition has been filed, a response deadline has been set, and the clock is ticking on one of the most consequential Second Amendment cases of our generation. Let me walk you through exactly how we got here, what the arguments are, why legal experts are watching this so closely, and what the government's next move could tell us about the future of firearms freedom in America. This whole saga traces back to a man named Peterson and a search warrant executed at his property in Louisiana back in 2022. Federal and state law enforcement officers showed up and executed warrants at his home, where he operated a home-based federal firearms license. Among the items they recovered was a solvent trap. Now, for those unfamiliar, solvent traps are cleaning devices. They catch solvent when you're cleaning a firearm barrel, but the government decided to treat this particular solvent trap as a suppressor under the National Firearms Act, commonly known as the NFA. And just like that, Peterson found himself facing federal charges for possession of an unregistered suppressor. His legal team immediately moved to dismiss the charge. Their argument was straightforward but profound. They contended that the NFA's entire scheme of requiring registration and imposing a tax on suppressors violates the Second Amendment. It was a bold challenge, one that strikes at the very foundation of how the federal government has regulated certain firearms accessories for nearly a century. The district court, however, wasn't persuaded. They rejected the constitutional challenge and upheld the charges, so Peterson's team did what any determined legal defense would do. They appealed. The case moved up to the Fifth Circuit Court of Appeals, and that's where things started getting really interesting. When the Fifth Circuit first reviewed this case, a three-judge panel issued a ruling that was, frankly, a gut punch for Second Amendment advocates. They declared that suppressors are not protected arms at all under the Second Amendment, full stop. Under that reasoning, the government wouldn't even need to justify the NFA's restrictions because the Second Amendment simply wouldn't apply to suppressors in the first place. But then the political landscape shifted in a major way. A new administration took control of the Department of Justice, and with that transition came a seismic change in the government's legal position. The new DOJ reviewed the case and made a stunning concession. They formally acknowledged that suppressors are, in fact, arms protected by the Second Amendment. Think about the significance of that for a moment. The federal government itself told a federal appeals court that its own prior legal position was wrong and that suppressors do fall within constitutional protection. That concession forced the Fifth Circuit's hand. They had to withdraw their original opinion. You can't have a ruling standing that says suppressors aren't protected arms when the federal government itself has just admitted they are. So the court pulled back its decision and prepared to take another look at the case with this new reality in mind. Here's where the legal gymnastics begin. When the Fifth Circuit issued its revised opinion, many expected that since both sides now agreed suppressors are protected arms, the NFA's restrictions on them would crumble. That's not what happened. Instead, the court found a different path to uphold the law, and the theory they landed on has sent shockwaves through the legal community. The Fifth Circuit ruled that even assuming suppressors are protected by the Second Amendment, the NFA survives constitutional scrutiny because it functions as what they called a shall-issue permit system. In their view, the NFA doesn't ban suppressors outright. It just requires you to fill out paperwork, pay a tax, submit to a background check, and wait for approval. And since the government processes these applications using objective criteria without discretion to arbitrarily deny them, the court reasoned this is essentially no different from a shall-issue concealed carry permit. Under the Supreme Court's landmark Bruin decision, shall-issue licensing regimes for firearms have been treated as presumptively constitutional. The Fifth Circuit grabbed onto that framework and applied it to the NFA. Their logic was simple. If shall-issue permits for carrying handguns are acceptable under Bruin, then the NFA's shall issue process for acquiring suppressors should be acceptable too. And on the surface, that might sound reasonable. But when you dig deeper, the implications are absolutely staggering, and that's precisely why this case is now knocking on the Supreme Court's door. Why the licensing theory is so dangerous, the petition filed with the Supreme Court makes a critical distinction that the Fifth Circuit either missed or deliberately ignored. There is a fundamental difference between licensing and registration. These are not the same thing, and treating them as interchangeable opens a Pandora's box that could swallow Second Amendment protections whole. A licensing system verifies that an individual meets certain qualifications before allowing them to exercise a right. Think of a shall issue carry permit. You demonstrate you're a law-abiding citizen, you pass a background check, and you receive permission to carry. The system is designed around the person. Registration, on the other hand, is designed around the object. It creates a government database tracking exactly what firearms or accessories a person owns. It's not about verifying your eligibility, it's about cataloging your property. The NFA doesn't just check whether you're allowed to own a suppressor, it records that you own one, what its serial number is, and where it's located. That is registration, plain and simple. The petition argues forcefully that the Fifth Circuit blurred this critical line, and by doing so, they allowed the government to skip the most important part of the Bruin analysis entirely. Under Bruin, once a court determines that the Second Amendment protects certain conduct, the government bears the burden of proving that its regulation is consistent with the nation's historical tradition of firearms regulation. That's not optional, that's the test, but the Fifth Circuit never actually conducted that historical analysis. They simply declared the NFA looks like a licensing system and moved on. The petition contends that this is a direct violation of what the Supreme Court established in Bruin. And here's the part that should concern every firearms owner in the country. If the Fifth Circuit's reasoning stands, there is no clear limiting principle. If the government can save any firearms regulation simply by structuring it as a registration and approval system, then what stops Congress from applying the same framework to handguns, rifles, shotguns, or every firearm in existence? Register it, pay a tax, wait for approval. If that structure is constitutional for suppressors, the logical extension is that it would be constitutional for everything else. The petition makes this slippery slope argument explicitly, and it's not hypothetical fear-mongering. It's the natural consequence of the legal precedent the Fifth Circuit just created. The petition also takes direct aim at the NFA's $200 tax stamp, and the historical context here is damning. When the NFA was enacted in 1934, $200 was an enormous sum of money. Adjusted for inflation, that amount is roughly equivalent to $4,800 today. The petition argues, with considerable historical support, that this tax was never about revenue generation. It was deliberately designed to make ownership of NFA items prohibitively expensive for ordinary Americans. This argument carries real constitutional weight because the Supreme Court has a long and well-established line of precedent holding that the government cannot impose taxes on the exercise of fundamental constitutional rights. The court has struck down poll taxes on voting. It has invalidated special taxes targeting newspapers and speech. The principle is clear and consistent. You cannot use the taxing power to suppress a constitutional right. The petition draws a direct line from those cases to the NFA. If the Second Amendment is a fundamental individual right, and the Supreme Court has said repeatedly that it is, then singling out the exercise of that right for a special tax is constitutionally suspect at best and flatly unconstitutional at worst. The NFA tax isn't a general sales tax that applies to all goods. It's a targeted levy imposed specifically and exclusively on the acquisition of items the government has decided to regulate under this particular statute. That kind of targeted taxation of a fundamental right has been rejected in virtually every other constitutional context. Perhaps the strongest argument in the petition is also the simplest. There is no historical tradition in the United States of requiring citizens to register their privately owned firearms with the government. None. The founding generation didn't do it. The early republic didn't do it. The states throughout the 18th and 19th centuries didn't do it. Under Bruin, this matters enormously. The entire framework the Supreme Court established requires the government to point to historical analogs that justify modern regulations. If you can't find a historical tradition supporting your regulation, it fails the test. And the petition argues persuasively that the government simply cannot produce historical evidence of firearms registration schemes from the relevant periods. The petition even makes the provocative but historically sound observation that if the British Crown had attempted to impose this kind of registration and taxation scheme on the American colonists, it would have only intensified the revolutionary fervor that was already building. The very idea of a government maintaining detailed records of which citizens own which weapons was antithetical to the founding generation's understanding of liberty. They had lived under a monarchy that tried to disarm them. The Second Amendment was their answer. Requiring registration and taxation of arms would have been seen as a step toward the very tyranny they had just fought a war to escape. The petition is now officially filed and docketed with the Supreme Court. The government, specifically the current Department of Justice, has been given a deadline of April 13th to file its response. That response is going to be one of the most closely watched legal documents in recent Second Amendment litigation, and here's why. The DOJ already conceded at the Fifth Circuit level that suppressors are protected arms. So the question now becomes whether they will defend the NFA's constitutionality using the Fifth Circuit's shall issue licensing theory, or whether they might take an even more dramatic step. Will they argue that the NFA should be upheld on different grounds? Will they suggest the court take the case? Could they potentially decline to defend the NFA at all? Each of those outcomes would have radically different implications. Once the government files its response, the justices will review the petition in conference. They'll decide whether to request additional briefing, whether to deny the petition and let the Fifth Circuit ruling stand, or whether to grant certiorari and take the case for full argument and decision. If 4 justices vote to hear the case, it goes on the docket, and we would be looking at what could easily become the most significant Second Amendment case since Bruin itself. The stakes really cannot be overstated. A Supreme Court ruling in this case wouldn't just affect suppressors. It would define whether the federal government can impose registration and taxation requirements on constitutionally protected arms. It would determine whether courts can sidestep Bruin's historical tradition test by simply labeling a regulation as a licensing scheme, and it would establish whether the NFA itself, a law that has shaped American firearms policy for 90 years, can survive modern constitutional scrutiny. This is one of those rare moments where a single case has the potential to reshape the entire landscape. The petition is filed, the deadline is set, the arguments are sharp and well constructed, and now we wait to see how the government responds and whether the highest court in the land decides this is the moment to finally answer the question that has been building for decades. That's it for today, folks. See you in the next video.